Motion today, as the court's probably well aware, is to reconsider and is to alter, amend, or vacate.
Okay, have you already filed a motion? Didn't we hear a motion to reconsider previously in this case?
We did not, because I was here and opposing counsel was here previously, but it was with respect to a handwritten docket entry, and the court declined to hear it that day, opting instead to wait for the entry of the formal typed order.
Okay.
That order was entered, and that's the one I'm here on today.
Okay. Go ahead. Let's just go down through the various reasons here. The issues of fact previously outlined here supported by evidence are sufficient justification to vacate, alter, or amend the entry of the summary judgment. Okay.
Yes, Your Honor. The issues of fact that we believe still exist, that we believe the entry of summary judgment is not proper because that entry, those findings were tantamount to actually a finding of fact by the court. Number one, my client has firmly testified without contradiction and has put into affidavit form the fact that she was coerced, she was forced, she was told by her husband to be, we go to the lawyer's office today, we sign it today, or I'm not going to go through with the marriage. She loved the man so much, she felt coerced into signing it, didn't even read it. My client asked to talk with the lawyer who had prepared it, not her lawyer, but Mr. Head's lawyer. And that lawyer wasn't there. She didn't have the opportunity to do that. She didn't have the opportunity to speak with her own attorney for signing it. So, in an effort to preserve the relationship, she went forward with it, but it was under coercion. Another reason.
Okay, I don't want you to argue all your things without seeing the case. Is that one reason right there?
Surely.
You want to respond to that, counsel?
Your Honor, the plaintiff characterized the facts that she was coerced, but the law does not support it. If you take her own admissions, first and foremost, they didn't have to get married at all, much less on that particular day. Number two, the prenuptial agreement had been percolating for, I think, weeks or months.
Let's just deal with the coercion portion of that's what he's arguing right now.
Right. So I think, and there's a case on point that we've cited to the court, it was the Aubrey case, that's not coercion or duress. She did not have to get married.
Yeah.
Period. She did not have to sign the prenuptial agreement.
I don't, respectfully, I just don't buy that I don't buy that. I've seen no case law on it. If you don't sign this, we're not going to get married. Well, that'd be a good idea to tell him to take a hike. She loved him so much that she wanted to sign it anyway. I just don't see that. Just doesn't hold it. So I'm going to overrule reason number one. Let's go to reason number two. The fact that the plaintiff had the opportunity to consult with her family or to consult with an attorney of her choosing, or even consult with an attorney who prepared the document, is justification for setting aside the summary judgment and justification for voiding the prenuptial agreement. Go ahead.
Yes, Your Honor. I have cited in the memorandum I prepared.
Yeah.
I have cited several cases, not just from Kentucky, but from sister jurisdictions, which declare that each party should be allowed time and opportunity to consult with his or her own attorney. Each party should be allowed that opportunity, or else the prenuptial agreement can be determined to be invalid.
It's voidable then.
It's voidable, it is,
Yeah.
but it's a jury issue as to whether it is voidable.
Whether she had enough time to consult with is a jury issue.
I believe it is, yes.
Yeah. What do you have to say about that?
I don't think that the facts support that. I don't think there's a material issue of fact on that. And it goes back to.
Speak up a little bit, please.
Yes, Your Honor, is to say the parties came to Judge Prather's office well in advance of the date that they married. And I think Ms. Head acknowledged that there was a supplemental agreement prepared that addressed her primary concern that had to do with the residence. So in the document itself, which she signed, says, I've had full and fair opportunity to consult with the counsel of my choice. And she had, say, at least a period of weeks to do that. The facts show, and again, these are not controverted, the facts show that there was a supplement agreement entered into by the parties that addressed her primary concern. She signed it. She didn't have to.
I respectfully suggest, Your Honor, that she did not have weeks to do that. The final version of that document was in the lawyer's office. Mr. Head had apparently seen it, and my client had not seen that final version until the day she was forced to go to the office to sign it or not sign it.
Force, I mean, you talk about this force, I just don't accept the force on this thing. And the fact that there were changes that she was involved in, I just don't think there's a disputable fact. So I'll overrule you on that situation. Now let's go to number 3. The fact that the judge of the court declined to recuse himself from the case is justification for reconsidering or altering, amending or vacate the summary judgment if it is correct that the judge of the court had previously been involved in a practically identical set of facts involving a prenuptial. What are you talking about?
Your Honor, I don't have the investigation done myself.
Well, why would you make an allegation like
Because my
that that
client
acted
is-
like that I have been involved in some prenuptial agreement, which is absolutely false, it's spurious, it's contemptible to me.
My
Yeah.
client informed me of
Well,
that.
your client has very little credibility with me. I've watched your client for quite a while and throughout this thing, but here's the thing about it. It was brought up in the argument somewhere that she'd been involved in a similar prenuptial, not me. And when it was brought up in the argument, it really impacted me that she'd gone through other litigation about a prenuptial agreement, and now she comes back again and tries to set aside a prenuptial agreement with a respected jurist, and lawyer, and given this opportunity, I don't buy. And then she has you to make this allegation that I had been involved in a prenuptial agreement. I don't understand why you would even put that in a pleading if you hadn't done any investigation. I'm very disappointed that you would do that.
I said if because I
Well,
was.
yeah. The guy is a bigamist if it can be proved. The guy is a liar if it can be proved. He is this. I mean, I just don't go for that. And the reason the previous attorney, I really believe if you'd have been involved in this case from the beginning, this case might have progressed differently. But she was the one that got off the case. The previous attorney did, and asked me to recuse because she said I didn't like her or something. I don't know. Do you have any response to that?
Yeah, I would simply say, I mean, obviously, as a circuit court judge, you hear a lot of things, and you're in a position where cases are going to come before you that might have similar facts or similar legal principles. That doesn't mandate recusal.
It wasn't any case I knew about. It was the party. She'd been involved in a case like this, and we made it. Here's the thing about it. If you get somebody that has had a prenuptial agreement that's been litigated, and they come back to you and they say, well, I did another prenuptial agreement, but I love this guy so much that I decided I just had to sign it that day I was forced to do it. There's no education in the second kick of a mule. So, I mean, that hurt her credibility with me, but it didn't even get to the point where it was a fact. I mean, so I'm disregarding that particular argument. Further memorandum will likely be tendered herein about what? What will a further memorandum?
I didn't have anything additional to add beyond that. I was hoping that I could find
The
something.
court appears to
additional.
has not adequately viewed the whole record. I've spent hours and hours on reading memorandum and hearing things and trying to force discovery. It was like pulling a wisdom tooth to get discovery done in this thing because the resistance thing. So I don't see how I could be more familiar with the record than I am. And the court did not give plaintiff's counsel an opportunity to be heard on his own renewed motion for summary judgment at the recent hearing held on April the 25th. Well, if I heard the evidence and wanted and was going to enter a summary judgment one way, I can't do two summary judgments. They would be mutually exclusive. So I don't understand that argument. You got anything else you want to put on the record so you can take it up? You can take an opportunity right now.
Yes, Your Honor. The last point I would like to make is that Mr. Head himself agreed that after 10 years of marriage, he would put the house into my client's name, the house and land, and that just didn't happen.
Well, is that in the prenuptial
It
agreement?
was.
Okay.
Your Honor, what Mr. Head said is that he would either do a deed consistent with the supplemental agreement in the prenup or do a will. There is in fact evidence of record that he did a will. Bruce Orwin testified at some length by deposition on that. There's a unsigned copy of the will in the record. Unfortunately, the original signed will was never located, but he did do it.
What did the will, the unsigned will and the testimony that was testified had been executed?
Correct. And it was totally consistent with the prenup.
Do what?
It was totally consistent with the prenup. And again, Your Honor, I think this is a non-issue because my client's position has always been, we will honor the prenup. That's what our dad wanted. That's what he committed to do. And that's all covered by the supplemental agreement. So I think the whole argument is a red herring.
Is there any additional action by your clients that would be necessary to honor the prenup? What do you suggest still needs to be done?
Not to my knowledge, Your Honor.
At this point, Your Honor, my client has to ponder her option of filing an appeal to the status of the case as it is right now, or as it will possibly be after today's hearing.
Well, just let her file the appeal and we'll just take direction from the big minds in the Court of Appeals and the Supreme Court after they take a view of this. I don't know where they can get a real feel of this case unless they've lived through it like I have. So I wait for direction from the Court of Appeals or the Supreme Court, and we'll address it accordingly. You know, everybody's got a right to disagree with a sitting judge and appeal them, and I'll accept if I'm wrong, I'll accept it and we'll move on with it. Okay? Thank y'all very much.
Your Honor, I prepared an order earlier today and e-filed it. I got a hard copy if you'd like me to provide that.
Well, if it's e-file, we'll take a look at it. Okay? Thank y'all very much. Have a safe
Thank you,
trip.
Your Honor.
Thank you, Judge.